Welcome to Financial Ginger. I am your host, Jacob Johnson, and today we're going to talk about estate planning. It's literally a matter of life and death. So, quick question. If you got sued tomorrow, car accident, job site mistake, rental property issue, what would they actually be able to sue you for? Would an LLC save you? Would a trust protect you? What if you own a company? What if you're self-employed? What if you own a rental property? What if you've got your home paid off? Well, we're going to talk about that and more with Blaine Edwards. Blaine, from the engine room to a nuclear submarine to the boardrooms of Wall Street's biggest banks, Blaine has spent his career mastering complex systems. With 13 years of experience as an attorney, he blends high-level technical expertise and deep legal insight. He has degrees in data analytics, computer science, nuclear tech. After a tenure in intellectual property at a major Charlotte firm and a role in corporate risk at Wells Fargo, Blaine has returned to his roots to provide personalized legal counsel. His practice covers estate and business planning, family law and probate courts, and general litigation. A maker at heart, Blaine enjoys his position of CNC machining and enjoys the precision of CNC machining and 3D printing, a hobby that mirrors his meticulous approach to law. He loves being with his wife and sons and loves skiing, even though there hasn't been much snow. Welcome to the podcast.
Thank you. I really appreciate being here.
Yeah, I'm excited. because I have been saying since I started that I want to interview someone that's familiar with law, because I want to really get into trusts and estate planning and all that, because some of it is me wanting to know for myself. And some of it is I think it'd be super helpful for people that are listening, because a lot of people hear they should get a trust or an LLC or whatever for their home or for vehicles or whatever. And it's like, okay, well, how does that actually help you? Before we dive too much into it though, I have a segment I do called Insurance Fails, and I would love your insight on this. So I'll read a story, I'll share my thoughts, and then I'll get your thoughts on it.
Glad to.
Okay. So this comes from Reddit user Chi Snowman. There we go. Chi Snowman. So, my deceased mother's home caught on fire. Will the insurance cover the expenses after we get the home switched over in my name? Years after my mother passed away in August of 2021 and left the house to me and our oldest brother, we stayed in the house and paid the mortgage. Sorry, some of the English isn't great on this because I literally got this off Reddit. Me and my oldest brother, we stayed in the house and paid the mortgage and did not switch the insurance or the mortgage over to our names because we recently had a horrible house fire in December and we started the claims process to try to get the home fixed. We were able to put the home in my brother's name after the fire and are currently waiting to see if the insurance company will cover the house. Update, our house isn't covered. What do I do? So this is terrible. And I laugh a little bit because it would seem obvious to me that when someone passes away, and this has happened with my clients, that you need to, as soon as it's out of probate court, if it goes to probate, or if it's in a trust, it needs to be, the insurance policy should be updated to the person that owns it. There was a similar story I read a little while back about someone that their mother had passed away in like 1999 and they kept paying the insurance for 20 years in their mother's name. The insurance company can deny claim for that because it needs to be written with an insurable interest. So if you own the home now, right, it's been transferred to your name, or if the person's deceased, yeah, the insurance company could deny a claim if it's not the right name of the person. And it's terrible that's what's happening to this individual, but that's kind of the way the legality of it works. You have any insights?
Yeah. As soon as you start taking possession of a home and you're in the probate courts, obviously when somebody dies, the house is going to immediately go into the estate to begin with. Okay. And then when you transfer something over, you have to do your due diligence. And so wherever that house is going to end up, so if it's going to go to you personally, to a person personally, then it's time to start getting everything up to date and not rely on what has been there before, but actually go and do things that you need to do.
Yeah. So, yeah, that actually hits a little bit home because my grandparents recently passed away and they're in the process of the house was in a trust. So there's some stuff there that, well, I actually don't know exactly how that's beneficial. So I hope we can get into it. Well, maybe we should start there. Let's start talking. Oh, sure. I forgot to say, I always say, if you have a story that you want to share or want to ask a question, send me an email, thefinancialginger@gmail.com, and we will answer them on the podcast. So let's get into it. Trusts. Could have a trust helped with that previous situation?
Well,
or that made it worse? Or just different?
Trusts just aren't bulletproof by any means. I think really to get into trust, we have to understand what a trust actually is and how they can be beneficial. So the way that we normally why we use a trust is so that when somebody passes away, that this entity, this trust, will be the one that's owning the property and not that individual.
So it avoids probate completely.
It can for that, whatever is in that trust, that will avoid probate, because here in Utah and in many jurisdictions, we have these limits that trigger probate. Okay. So here in Utah, anytime that you own real property, it's going to trigger probate. And then anytime that you have assets over $100,000, you have to go through probate. Gotcha. So if you have either or of those scenarios, then you're going to go to probate. Now, let me back up and just say probate is not this terrible process here in Utah. It's actually, if all the siblings or whoever the beneficiaries are, if they're all in agreement, it can actually be a very slick process. Okay. And you don't need to go through the rigmarole of having a trust and all this stuff. Where the trust helps you, though, is in a few areas. One, if you know that kids are going to be, that there may be kids that aren't going to agree and they're going to take it to court, a trust can help protect against that. But if they're going to fight it, they can still fight a trust as well. The other area where it helps, though, is it keeps things private. When you go to probate, your entire life history for your assets becomes public, because you have to probate the will, and if there is a will, and even if there isn't a will, then you have to do this accounting that does go in front of the court, and then the court has to approve it, and it's a public record.
It's a public record.
So trusts help protect against
privacy.
That. Yep.
So it's more than just financial. It's way more than finance.
Yeah, and there's tons of trusts for different scenarios, but for the average person, the reason why they're going to want to do it is because they've heard that probate is bad and that we want to avoid it. And it's a legitimate reason. Yeah, I'm not saying that a trust isn't necessary, but that
probate's not as scary as people make it out to be.
Exactly. And so we have two types of trusts. That one is called a revocable trust, meaning that at any point in time you can go and change that trust. Okay. The other is the irrevocable trust, where at least a portion of that trust is the person who created it can no longer modify it at any point in time. It's locked in. And we do that for asset protection and for advanced planning. So for the average American, what they're going to do is what's called the revocable trust. And when we set up these trusts, we're going to put assets into the trust. Okay. And this is a common misconception and a huge pitfall that people have when it comes to trusts, is that when they set up a trust, they have this idea that as soon as they sign that document, they are good to go. And that is not the case. A trust is another person that you're going to give property to.
You have to actually transfer the stuff to that entity.
That's correct.
You have to go to the bank and sign it over from yourself to the trust that you.
That is correct. And so, and specifically in real estate, we have to record a deed that transfers the property from the individual that owned the property initially to the trust.
Yeah, well, and can't that trigger? So I'm kind of concerned because I've heard people that they do something like that, and then their mortgage calls the mortgage, because it's like, oh, a different entity now owns the property. You don't own it anymore. We're gonna do on sale clauses or whatever it is with certain mortgages, where it's like you have to be careful, because if you do it wrong, a mortgage company might say, oh, you need to pay out the asset, or you have to refinance or whatever. Like, is that a real danger that can happen with a trust?
It is. Mortgage companies, more so
with an irrevocable compared to revocable, or it could happen to either of them.
It can happen with both. It's always nice to contact your bank ahead of time and just to make sure that this is what we're planning on doing, and get a release from them in any way, shape, or form to say that that they know what's going on, and so that if they have this due on transfer clause in their mortgage agreement, that
Yeah, you're not going to mess yourself up.
Yeah, you're not going to mess yourself up.
And have to refinance your 2% mortgage right now.
Yeah. You definitely don't want to do that.
Okay.
For the most part, though, banks are normally good. From all the banks that I've worked with, they're
probably more concerned about like an LLC transfer because that looks more like a business entity.
Yes, that is correct. And we can talk about LLCs and how they can be good for doing estate planning as well. But I think the main thing that I just want to like get across, because it's such a big misconception, and so many people that I've talked to in the course of they tell me, hey, I got a trust. And then I say, well, is the house in the trust? Well, I don't know. And then we go and look it up and it's like, no, you never put the house in the trust. Well, what happens if that person dies? Is the house isn't in the trust? It's theirs.
It still has to go through probate.
It has to go through probate.
This episode is sponsored by Prime 90, a supplement company that I've used for almost a decade. 5 years ago, Prime 90 was helpful for our rescued cat Mischief, who was severely underweight. With consistent use of Prime 90 with her food, she regained strength and is now a healthy weight, even at 20 years old. Even after a stage 3 kidney disease diagnosis, she's still doing well and more energetic than she was at 15. I use their Nutramax canine supplement for my cat, even though it's formulated primarily for dogs. But they have specialized supplement for all of your pets: cats, dogs, even chickens, horses, and cattle. I personally use the Human Complete Mineral Supplement to support my sleep, energy levels, and post-workout recovery. Their bottles contain a full 3-month supply, which is so different from the normal 30-day supply that other companies do. I've trusted Prime 90 for over a decade. If you want to try it yourself, go to prime90.com and use code GINGER15 for 15% off your first order. Try it risk-free with their 30-day money-back guarantee. My favorites are linked in the description. Thanks, Prime 90, for sponsoring this episode.
Now, could a trust, because I know, and part of this might be a little bit high for some of the people that are listening to, but I know usually if you own an asset like a home, when you die, if it goes to your children, there's a step up in basis. If you put it into a trust, could that potentially nullify that step up in basis?
So that is a very good question. And
that's why I'd be scared to put a property in a trust. It's like, oh, well, if you bought it for $100,000, it's now worth $1 million, right? Like just rough examples from people I know that bought houses in the 90s for $100,000, right? And it's like, oh, your home's worth $800,000 now, 850, 900.
Yes.
It's like, oh, well, your basis was lower. It's like if you died and you transferred to your kids, they might get a step in basis, so they don't have to pay taxes on that $800,000 difference. So yeah, that's why I'm concerned a trust could potentially ruin that.
Yeah, and what we're really worried about is capital gains on the sale of a property. And when we have step up in basis, IRS has given us this really sweet deal that says that if mom and dad owned a property, they bought it back in the 70s for $50,000, and now it's worth $800,000 today. When mom and dad die, and they have to die, and they transfer the house to the kids, then the kids receive it at the value as of the date they died.
Yeah.
Yes.
And that avoids you having to pay $800,000
in capital gains, $750,000, which is, it can be significant.
Yeah.
And so it's a great deal. So yeah, the big question is, if I transfer it to a trust, this property to a trust, does it nullify that step up in basis? And the answer is no.
Oh, cool.
So there are no problems with that on a revocable,
it's just that person has to die.
Trust. Yep. That is the main thing. And so, yes, if you have a trust, the house is transferred to the trust, and then whoever the trustee is sells the house before parents die, then unfortunately
that's a problem.
Yeah, you're gonna trigger a max. You're gonna trigger a tax bill on that one.
So, but that one theoretically would be owed by the estate, which is still bad.
Yeah, I mean that's less inheritance for the kids.
Yeah. Okay, so because this is very relevant to me because I've had grandparents that recently passed away, and they're like in the middle of, and I'm sure they've I'm not involved in that. I'm a grandkid, right? Like I'm not involved in all that. That's the 9 kids that are dealing with that and all that. But I'm always interested to know how that would work, because I would, So that's great. That's great to know. Pardon, I feel like I derailed the conversation twice talking about trust, because I just am so fascinated with this. A lot of people I feel like think trusts are just for rich people. Like why would that why is that true or not?
No, it's definitely not true. Are they overused? Maybe so. I don't think that everybody in the, that's middle class or whatever needs an actual trust, especially where they are in the time of life and such. And it's hard to say whether there's a trigger point where you would want to have a trust because they can be good for different purposes. If you don't have a trust, of course, then and you have just a will in place, that's fine.
Wills are great.
Even if you have a trust, you better have a will. That's and whenever we have a trust, we have specific types of wills called pour over wills that just say that whenever I die, my intention was for everything to be put into a trust.
Just in case. And so even if it triggers probate, you trigger probate, then it says, I anticipated this to go into this trust, and whoever my personal representative is going to transfer that to the trustee of the trust, and then the trust will decide what to do with it. Oh, I see.
So we have this, instead of having multiple documents that dictate where your property is going to go, it just says, give it to the trust and let the trustee decide what to do with it based upon my trust document.
Because a trust can kind of function pseudo like a will, right? Like if you put the way that the assets are going to be distributed after you pass away in your trust, then you might not need to worry about it. But you definitely want that pour over will. So anything that you missed after you pass away, your kids can, or whoever the head of the estate is, can put them into the trust and then deal with them accordingly.
That's right.
Okay.
And so when we're with a trust, it's testamentary in nature, just meaning that it's meant to pass on things after a person dies. But, it's more than that. A trust can be more than that. It can be thought of as a business entity in and of itself, in that it can serve, very specific purposes. And it doesn't mean that a trust document can be written such that unlike a will, where the purpose of having a will is to just pass on property and wrap up the affairs of a person's life, a trust can actually be written to continue on and serve as long as it has some purpose and it has some beneficiary. And then finally, as long as it has somebody to manage it, then a trust can last a lot longer.
Yeah. Well, so here's actually an example. I don't know why I didn't think of this beforehand. This was actually something I had to deal with the insurance on. There was a guy he was remarried in his late 60s, right? And they both had their own kids and whatnot. And so he had a trust for the home that he owned, right? Before that they got married. And so he had his trust. I think it was one of his kids that was the head of the estate afterwards. That as long as his wife continued to live, the home, she could use it as a residence, right? And so the trust paid for the taxes, because the trust wholly owned the property. There was mortgage free. The trust paid the taxes. The trust paid I think it even paid the light bills and stuff like that from money from his trust. And then it was after she dies, then the home is to be sold and split among my heirs in this way, right? So that could theory, it's still alive today, that trust, and he passed away 6 years ago.
Yeah, trusts are amazing in what they can do. And normally when people talk about estate planning, we think about, husband and wife, kids, and, single family, but they can be used in so many different scenarios exactly like this, that they can be used to take care of a second spouse. Where dad's remarried or mom's remarried, then there's kids from the original marriage that want to take an inheritance. You can specify how that happens by setting up a trust and of course, in my area of family law too, we have other documents that we're going to put on top of that, like marital agreements, the prenup or postnup agreements that help to define and dictate how those things go, so that everybody is comfortable in those types of scenarios.
Or more importantly, the person who's controlling the assets is comfortable.
Yeah, that's right.
Lots of situations where some kid's upset because they're written out of a will or something like that.
Yes.
And it's you're not comfortable, but they're comfortable with how they made the decision, and it's going to happen that way.
Yeah. Beneficiaries, Sometimes you just gotta, yep.
Sometimes people that don't want per stirpes or things like that, it's like, oh,
Yes.
wait. Yeah. I've seen situations like that where the way a will is written, it's like, oh, well, because my kid died before me, my money's only going to my kids. And
That's
so the
right.
money isn't going per stirpes to that deceased child's grandkids or whatever. And it's fancy terminology that I've heard over the years. My degree was in financial planning at UVU.
Yeah,
and so like, this is the sort of stuff I crave to be involved in. And of course I ended up doing insurance, but so I know a little bit about it, but not enough to actually.
Well, and that's important to know is that,
how do they want their money used?
so, I think that really goes into the idea of what happens if you don't have any planning that's done.
What happens if you don't have a trust or a will or anything and you pass away?
So there's two things that can happen when you die. One is you have a document in place that says how things can happen or the way that things will happen. That's called a will. And when a person dies with a will, they're said to have died testate, meaning that they've given this testamentary document out there that says we're going to do it this way. Well, if you don't have that, or worse off, if you have part of your will that's not valid for whatever reason, let's say that you did everything right, but you didn't have the witnesses. And heaven forbid, if you ever do a holographic will, don't ever do it. But it doesn't require witnesses. But
you just write it down and sign it
you
yourself?
Just write it down yourself and sign it yourself.
Yeah,
don't
very
do that.
contestable.
Yes, very. So if you have a will, and let's just say it wasn't properly witnessed, then it will be as if you didn't have a will to be going with. You'll die what's called intestate. And then when that happens, the laws of the states of wherever you died, or where you're a resident here in Utah, it says that it will be divided amongst your heirs at the first level where your heir can be found. And so normally it's your kids. Well, if you want to disinherit a kid, or in some scenarios, what I've seen is that people want to add somebody in, then that's going to happen. Another typical scenario is what happens to a child that passes away before their parents, like you brought up, and should it go to their kids or should it go to their heirs? Meaning that it goes to a spouse of their, and so all these things can be, need to be talked about. And if you die intestate, well, you're kind of rolling the dice on your wishes actually being met. Yeah. Now, we can always specify this in a trust, just like we can in a will, but we always want to have the will in place. One, just in case, hey, you found out you won the lottery the day after you died and you didn't have time to put it into the trust. Then, of course, that's going to go through probate. And so we want to make sure that eventually gets to the trust so the trust can decide on what to do with it. Yeah.
Or I saw a weird situation where someone's Roth IRA, like a retirement money, they'd set it up when they were like they worked at the same place for like 40 years, right? It was in their deceased mother's name, like the beneficiary when he passed away. It wasn't put to be the tricks. I don't know if you can transfer a Roth a retirement account to a trust while you're alive because it's a personal account.
That's right.
But so that one would have to be handled by a pour over will, right?
Yes.
But the beneficiary listed on the retirement account was his own mother, who was deceased at the time. And so I don't know exactly how that one worked, but I assume it just went probate.
Well, and that brings up a good point. I mean, there's
Make sure you update your accounts.
Yes. Rule number one.
On your life insurance.
Yes. And insurance policy, life insurance policies and IRA accounts, retirement accounts are all testamentary in nature. They can be a testamentary in nature, meaning that you can specify a beneficiary. Well, you can always specify the trust as your beneficiary. And so that it all funnels into one place. Now, there's some tax implications that are associated with that. That would probably be too much for the scope
of this episode. Yes. There's tax implications.
But if you don't name your beneficiaries correctly, and you don't have somewhere where that property is going to go, then it's going to default back to to the estate,
To the
and
estate.
then the estate decides what to do with it.
Yeah.
Same type of thing. If for some reason you die intestate, then the state's going to dictate how that money's going to be distributed. Doesn't mean the
state doesn't
state
control
gets
the
it.
money, but
Right.
they're whatever laws or procedures, like the default is, like you said, like your initial heirs, it's split equally among the first level of heirs that are found. Like if none of your kids are alive,
That's
and
right.
it's equally split among your grandkids or whatever, right? Like the state has their own rules
Mhm.
for how they're going to deal with it. And I imagine that can get more complicated if you like own assets in different states and all that.
Oh,
So
yes.
yeah. Wow. I didn't realize I had this many questions. I knew I was going to have a lot of questions because I think this is just the coolest area.
Yeah,
be
I
aware
mean,
of.
like I said, when we normally think of estate planning, we think of a standard middle class American family where it's husband and wife, kids,
Yeah.
and that is. Of
Becoming
course,
less
those families
common.
exist, but
Yeah.
a lot of the time we just have so many different
Yeah,
scenarios.
like what if you adopted a kid? That might be different, right? In terms of
That's
how you
right.
put it, or there's a lot of things.
So, as opposed to English law, when you adopt a kid, it's as if they become your natural kid.
That's good to know.
And so, if you're worried about, do I have to do anything different? It's absolutely not. As soon as they are adopted, they are your child.
Oh, cool.
And they will. So, but if you want to disinherit them, of course, you got to do a will to
Yeah.
disinherit them. Otherwise, they're going to take.
Yeah, because they have a claim to it naturally by natural, or I don't know what's the right. Is natural law the right word for
Yeah,
that?
it's as if they were naturally born to you.
Yeah. Cool. Well, okay. I want to talk a little bit about the asset protection side. I feel like we've talked a little about the estate planning side. A lot of people think that trusts are going to help protect their asset if they're sued, right? Like I mentioned in that awesome cold open, right? What if someone falls off of the back porch because it wasn't built properly and they sue you because you're the landlord, or slips on the ice and sue? Like, how could a trust does or doesn't protect them from their asset?
Yeah, this is a good question. And this, I have to go back and say the difference between the two types of trust that we have are revocable trust and irrevocable trust. So in a revocable trust, you have control over the property in that trust, because at any point in time, you can move property in and out of that trust. You can modify your trust at any point in time. So for purposes of liability, we always consider the property that's in a revocable trust as if it were your own individual property.
Gotcha. So that doesn't really provide any meaningful
No
liability
protection. Nope.
Okay.
So
because you still have, you basically have complete control over the asset.
that's correct.
Okay.
And so there, to nuance that, then on the irrevocable side, we have more protection, but it has to be done right.
Yeah.
Okay, so the trust, we can set it up like it were a business, meaning that the property is in the trust and it can't be transferred into or out of the trust, or nothing can,
Yeah.
like we can't change the trust, so to speak. In those types of scenarios, we have more protection on it, but we have to be careful in a lot of different ways.
It's not absolute protection.
That's right. And so some people will set up these trusts, these irrevocable trusts, so that they can avoid liability in some way, shape, or form. The classic scenario is that you buy a house, you get a mortgage on it, and it's in the name of the trust. Then you decide to just declare bankruptcy, whatnot, within a short period of time later. Utah, like many other jurisdictions, has anti-fraud statutes that don't let you to do that.
That makes sense.
So you can't.
There's certain legal things that are like, okay, we obviously know someone could do this, so we're just going to say you can't do that.
That's right.
Put it in an irrevocable trust, declare bankruptcy, because then it's protected completely, and it's not.
No, it's not, but it can be used for asset protection.
Yeah.
It just has to be done correctly. So if you're getting into a risky business such as law, it may be beneficial to create a trust knowing that you may get sued at some point in time. And it's not anticipation of of defrauding somebody. It's just knowing that you're going to be in a risky business and you want to protect certain assets. We have look back laws to say within a certain period of time, if somebody has a claim against you, they can go in and reach into this trust and pull that property out. But if it's been long enough and you didn't do this in anticipation of trying to defraud somebody, then it's going to stick.
Like putting a house into an irrevocable trust right before getting divorced.
That
right. might trigger that.
Yeah.
Because I've heard with and pardon to step back into the estate planning side, sometimes it's like, oh, if you make a trust within like a year of someone dying or 2 years, like if it's really close to when they actually die, it might not actually keep it out of probate because of the look back laws.
Well, and that you're going to have a pretty, for the court's purposes, they're gonna be okay with it.
Oh, gotcha.
They're not gonna say that that they're gonna haul you back into probate, but that doesn't mean that probate won't happen.
Gotcha.
Okay, and this is an important distinction. The courts may not require you to do probate, but let's say there is a creditor out there and they're owed a lot of money, and then they can go and ask the court for a probate.
I see.
And then say, well, here's this trust. It was just set up. We believe that it was set up for the purpose of defrauding us. And then they can claw back that property.
I see. That makes sense. Okay. Sorry. This is just too much. This is exciting. I'm like overwhelmed with just how exciting this information is.
Well, and I think there's another scenario that will probably be more beneficial, and that's with LLCs. If you want to talk about that right now, or if you have other questions about trust.
Yeah, let's talk the asset protection side a little more, because I kind of interrupted a thought you had out of that, and then we can move to LLCs.
You bet.
I can't remember what it was I was fully asking about asset protection. You were talking about the typical situation why someone might set it up and defrauding people. What's like an actual situation where the trust is going to protect the asset? Like maybe the example like a dog bite claim, right? Like someone's dog ripped. I actually had this happen with someone that we insure. Their dog like basically removed the face of a small child.
Oh yeah,
it was a very expensive.
Those are terrible.
Claim. An umbrella policy came in. There was over $1 million paid out.
Yeah, and
obviously the family absolutely deserved that sort of right, like the surgeries and stuff that she had to go through and whatnot, and the dog got put down and all that. But it doesn't change the fact that it happened, right? And so there was insurance. But let's say they didn't have an umbrella policy, right? And they only have $300,000 of liability, and they're being sued for $1 million or $1.5 million after this incredibly bad dog bite situation. How could a trust or potentially protect that asset?
So unfortunately, a trust isn't even going to protect under that, just because it's going to be under premises liability. And let me explain what that means. Sure. Is that dog bites here in Utah are strict liability. Okay, meaning that whoever the owner is, they're going to be personally liable for that animal. And so since you can't put a pet, so to speak, into a trust, then unfortunately that person is going to be personally liable, strictly liable, meaning that they don't have to prove negligence or anything like that. The fact that it happened and you can show who the owner is. Doesn't matter if the dog had a propensity to hurt somebody or anything like that. Here in Utah, if a dog bite, for the most part, is gonna get you a lawsuit.
Gotcha. But if they didn't have, like, let's say they got the lawsuit and they don't have assets and they need to declare bankruptcy basically because they don't have the assets to do it. A revocable trust wouldn't protect the asset, but an irrevocable trust
definitely can't protect that asset.
Prevent them from having to sell that home to pay that bill before declaring bankruptcy.
That's right. Yep. And so because
it doesn't prevent you from being liable, but it can prevent you from having to sell that asset.
That's right. And unfortunately, it's so nuanced in some situations that whoever's going to be the beneficiary of the trust, it's so tough to tell, just from an initial standpoint, just to say that, trust equals prevention of liability. It's just not that way.
It's not that simple.
Yep.
Gotcha. It's theoretically, it could potentially do this in a situation, assuming it's set up right. And
that's right.
It gets messy really quick.
Yeah. Because, when we set up trust so that, and we put houses into trust for protection, of course, and But whenever we have somebody that's able to be the beneficiary of the trust, let's say it's mom and dad set up the trust, they do it right, it's asset protection where they're not the trustees of the trust but give it to the kids, but then they're beneficiaries. Well, there's still an opportunity to go into that trust and start to get that property that's associated with that trust.
Gotcha.
So unfortunately, it's not a straightforward.
Fortunately, because maybe that's fortunate for the person who was injured by that person's dog.
Yep.
You know, like, so there's unfortunate. Yeah, totally. Okay. Well, maybe that's a good segue into LLCs. How might an LLC protect an asset differently?
So an LLC, and unfortunately, the dog's still going to be the dog, and the owner's going to be the owner of that dog. But very similar to a irrevocable trust, Utah, and I'll say this a lot, like many other jurisdictions, states out there, we have LLC laws that allow us to create these entities, just like a trust, for the purpose of holding property. And it's a company, limited liability company, LLC. And so instead of beneficiaries, we're gonna say members. The members are the ones that own more or less the property that's in the LLC. And so if we look at it from a trust standpoint, we would say beneficiaries are the ones that benefit from the LLC, and they're not necessarily liable for the LLC, for the trust, but in an LLC, the members receive the benefit, but they also have some amount of duty that goes to the LLC as well, or to the company. Yeah. So there's trade-offs, but
it's basically just like a business, right? Like I have an LLC for my insurance business.
Yep.
I am the only member in it. I manage and run it, right? But I also get paid by the income that the LLC produces.
Exactly. And it's a wonderful thing. Now, as far as limited
taxes.
Yes.
Dramatically.
Yes, it does. Especially if you get that S-Corp status.
Yeah.
But for limited liability protection, what we're mainly focused on is the liability is strictly limited to that company, meaning that if it owns a debt, then whoever, gets paid for on that debt, they can't go outside that debt. They can't go for you to collect on that bill.
Like if Walmart gets sued, they can't go after the CEO of Walmart's private home because he's working for the company. It can only be things that are connected to Walmart, even though he's a member of that group. But then on a really small scale, right? If it's the house is the member. Okay. That makes a little more sense.
So a common scenario that we have in here is somebody has a rental property and they don't want to put it necessarily into a trust. And so the typical scenario we would do is to create an LLC for the purpose of holding that property. And so if somebody were to get injured on that property or whatever, the liability stops with that property. Now, unfortunately, you may lose that property depending on what happens. But that just means it doesn't go outside.
Yeah.
So if you have multiple properties, well, let's set up multiple LLCs. Then each one the liability is limited to each of those LLCs. So they can't come after, the other property that you may have.
Yeah,
it's isolated for that one property.
See, because I've got 2 rental properties right now, and it's like, mine are just directly in my name, right? There's no LLC, there's no trust. But it sounds like if I wanted to do an LLC, the big thing would be to make sure the mortgage company isn't going to trigger a due on sale clause, because again, that's another transfer, which is probably more intense than transferring to a trust. But if you work with the right mortgage company, I'm sure they'll be okay with that. Because why you're doing it, that totally makes sense. Obviously, you can do that because it's not going to affect their ability to take the property back if you default on the loan.
Yeah, that's right.
They should still be able to do it.
Now, unfortunately, most mortgage companies are going to. They may say, we'll allow you to put the mortgage into the LLC, but they're going to want a personal guarantee that's
on top of
associated
it.
with it. Yeah, that's so unfortunately, the cold hard reality is mortgage companies, this isn't their first rodeo.
Yeah.
And they want to make sure that they're going to get paid at the end of the day.
Yep. If there's no problem.
And so if you sign a personal guarantee, then yes, they can reach outside and come after you.
And that's specifically
personally.
just for the mortgage.
That's right.
Yeah, just by signing that for the mortgage, it doesn't open you to more exposure from someone that isn't between that agreement is different. Right?
That's right.
Okay, cool.
Yes. If somebody were to get hurt on your property,
They couldn't say, "Oh, you made an agreement with the mortgage company. There's this weird way I'm able to come back and get you." No.
So there is one caveat, though.
Ooh, we love it.
Yes, there's always caveats. So just because you have an LLC and just because you've done everything, you've transferred the property into the LLC does not mean then that you're not scot-free. Okay, if you don't treat the LLC as if it were its own entity. And we call this alter ego theory. In other words, you treat the LLC's bank account as if it were your bank account, or you don't have any formalities with how you move money in and out and whatnot. A person can potentially ask the court to do what's called piercing the corporate veil, meaning that there was no distinction between you and the LLC. Therefore,
It's defunct.
It's defunct. And they can come after you personally.
Interesting.
Financial Ginger is brought to you by, well, me, the Financial Ginger. If you live in Utah and need auto or home insurance, I am your local independent advisor. I broker for nearly 25 insurance companies, which means I can shop the entire insurance market for you to make sure your rate and your coverage fit your situation and not some company quota. When you call, a real person answers the phone during business hours. No phone trees, no pressing 1, 3, or 7 just to talk to a human. Email jacobinsuresutah@gmail.com or call or text 801-216-8444 to get your quote today. Now back to the episode.
So you definitely need to set up a separate bank account that's paying for things and managing all that.
Mhm.
And then if you're taking a distribution for ownership of the property or cash flow or whatnot, having a specific way that it's like, hey, once a year or once a quarter, I'm taking a disbursement based on excess
Yes.
funds above the operating limits or whatever it is. Interesting.
Yep, that's exactly right. Now, with an LLC, because it's its own entity, you have to have its own federal tax ID number.
Mhm.
With a revocable trust, you don't need its own federal tax ID
Less
number.
paperwork.
Yes, less paperwork. But the nice thing is both you pay taxes on both the same
Yeah.
way.
Okay.
Which is nice.
About to say, I think mine's like a Schedule K or something like that.
Yep.
The rental income. Yeah. And I'm doing taxes right now. In fact, my tax appointment's
Yeah,
on
it's
Friday.
that time. It's that time.
Wow. Okay. That's cool. It's cool to know a little bit more about the way those LLCs work and the way that they can be pierced and become defunct for not managing them properly. But that sounds like a great way to protect. One thing that I want to bring up is the insurance side of that, right? Just like you need to reach out to the mortgage company if you're doing it, make sure you're doing it properly and properly separating them with the bank accounts and everything like that too, is make sure you notify your insurance professional, because it's just like, right, the mom that passed away 20 years ago, you need to write the insurance in the name of that LLC. So sometimes, and this frustrates some people that talk to me about this, they're like, I've already gone through and done all this. I never talked to you along the way. And I'm like, oh, well, you have a personal home insurance policy. Now that it's in an LLC, we have to do a commercial insurance policy,
Yes.
right? Or we have to do a personal policy with a carrier that can write an endorsement for saying this is in an LLC, right? Because they understand it. Okay, yes, it's an LLC, but it's right. And some insurance companies won't do that. And so I said to somebody, well, like, we have to rewrite the policy and it's more expensive, 20, 30, 40% more expensive than the old policy. And they're upset about that. I'm like, yeah, well, this carrier won't let you do that. Or they could deny a claim that arises from it because you don't own the property. It's now an LLC that owns it. So that's one more thing to add to your checklist while you're doing this is check with your insurance agent. It's not the huge end of the world, right? Like if it's $400 or $500 a year, I imagine setting up an LLC and going through all that paperwork is more expensive than that. But be aware of the cost.
Well, actually, setting up an LLC is pretty straightforward and simple. And the cost to set it up, well, as far as just the fees and stuff, it's actually very minimal. And then the yearly maintenance, and that's important. Just because you set up an LLC doesn't mean that you don't have to do you don't have annual maintenance that you have to do. Yes, make sure you keep up on all of that. But for the most part, an LLC is a very easy to manage entity. Now, with a trust, you don't have all that. You don't have all these statutory requirements that you normally would with an LLC. And so you set up a trust. You don't have to go back to corporations division with the state of Utah and to pay your annual dues and send in your update sheet and all that stuff. You don't have to do that. But sometimes it just makes sense to do an LLC, and sometimes it makes sense to do a trust. Sometimes it makes sense to have a trust own the LLCs.
Oh, I didn't even know that was a thing.
Oh yes, it's in estate planning. I think this would be a podcast episode by itself. We don't have time to get into we this. Do not. But just that there can be complex structures to give you layers of liability protection.
Whoa. Oh my gosh. Yeah. A bunch of LLCs that are in a trust that wow. A revocable trust. I'm just kidding.
Sometimes it makes sense. And sometimes, and again, just for the sake of time, that's something that we haven't considered before is even how to take care of mom and dad using trusts.
Oh.
But elder care planning is another part of trust that's very important. We use them
in medical power of attorneys and all that. And that is a definite extra thing. Well, we'll have to do this again and talk about them at some point. That's fascinating. Just thinking about how all that works. And I was really assured by you saying probate isn't as scary as some people make it. Mm-hmm. Right. So I think the real key, and I say this all the time on this podcast, is you don't need to know all of this stuff as a listener, right? They don't need to know all of this. They need to talk to a competent professional that knows what they're doing to do it the right way. Right? Like I have a real estate agent, they're talking to me about, they're like, oh yeah, my friend puts his properties in LLCs. And I remind him, oh, you have to change the insurance on that. It's like, oh, I need to remember that. I'm like, no, you don't. And your friend has a question, you say, go talk to Jacob. That's my insurance guy. Right.
That's right.
And I'll ask the questions when I'm doing the insurance and make sure that it's done properly. Right. If you're like, oh, when I die, I want my property to do this and this and this, and I'm worried about liability in this. Okay. Talk to Blaine, figure it out. Get the appropriate structure for you. Maybe the right answer is an LLC. Maybe the right answer is a trust. Maybe the right answer is a simple will, and what you don't need anything fancy for it, right? Like it's okay to go through probate maybe, right? Like, or whatever. Just know what it is. And most importantly, don't be intestate. Don't not have a will. Get a will.
Yeah. Yeah. There's just a lot of people out there that think that, and I don't mean to be that attorney that says, you can't do it yourself. Sometimes it's going to work out, but sometimes it's not going to work out.
A holographic will.
Yeah.
You just do yourself.
Yeah. There's no do-overs when it comes to estate planning. Once you die, it's kind of final.
Yeah. Oh, it's final.
Yeah. So it's a matter of life and death. Yeah.
Literally. Well, cool. Okay. Well, in our last few minutes, I want to, actually I should ask, was there anything else you wanted to cover? This was fantastic.
Yeah, this has been really fun. If I can just do a plug as far as estates are concerned, as you said, a competent professional can definitely walk through any individual on on the best way to use these structures, these entities for your advantage and to make sure things go where they need to go.
Absolutely.
Excellent.
Yeah. If people want to find you and say, hey, I need to talk to Blaine Edwards, how can people find you? Obviously, we'll put this in the podcast description as well, but quick shout out for best way to contact you.
Sure. I practice locally in Lehi, Utah, where I was born and raised. My law firm is the Novel Law Group, and my website is novel, novel.law.
Novel.law. Cool. Okay. One last question I want to ask before story. I always end with an ask an audience question. So these are questions that people have sent in or asked me about insurance, or insurance related things. And this one I think you might have insight on as well. So I'll read what the question was. Ask Jacob. So I asked my agent to add my daughter to our auto insurance policy a year ago. I just found out today they never did. I have emails showing that I sent her name, date of birth, driver's license number, and my agent even emailed me back saying that she was added. When I got a quote with you, I realized she wasn't there. So he got a quote from me and realized his daughter wasn't on the insurance. What would have happened if my daughter had gotten in an accident? I'll take a stab at it first, or do you want to take a stab at it first?
Well, you definitely want to come talk to me if you ever find it. If you're
definitely talk to an attorney if that happens. Yeah, just my perspective, really, really briefly, and you can add to it. Likely, they would have been covered. Insurance agents in the state of Utah do have binding authority. So if you have proof in an email, right, or a phone call recorded where they said, yes, your daughter's been added and covered, then my understanding is they should be covered. Now, the insurance carrier might deny the claim saying it wasn't added, but that's why insurance agents have to have errors and omissions insurance. So you can sue. Obviously, it's going to be a lot more difficult than a normal auto insurance claim, but it would theoretically be you go after your insurance agent's errors and omission insurance to cover the fact that they told you your daughter was covered. So if she caused an accident, $100,000, $200,000 of medical liability, property damage, repairing your car, your insurance agent's errors and omission insurance would theoretically end up paying for it.
Yep, I agree. And unfortunately, these things happen. Like the formalities have to be met, and sometimes they're not met even by us professionals. And that's why we have coverage ourselves. All professionals, based upon what we do, should have coverage so that we can protect against these.
Absolutely. Yeah. So thanks, Scott, for sending that question in, and appreciate you letting me do an insurance quote for you. If you have an insurance question that you want me to answer, leave a comment or email it to me at thefinancialginger@gmail.com. Thank you so much, Blaine, for coming on. This was absolutely awesome.
Thank you. This has been an amazing experience. I appreciate it.